All right. So,
Yes, sir.
evening once again, and okay, so we'll be taking business law as a run-up for the one we had earlier. So the main thing I had shared this material with the class earlier on the WhatsApp group. So this is just to quickly have a wrap up. So again, it's expected that we all go through this material, study this as expected. So this is just going to talk about the company law and then probably the business formation and the types. It's not something that should be technical, aside the fact that you've not been used to this. So, introduction basically, you have a promoter, the person who tries to form a company. It may not be the owner of the company by so doing. The promoter is just one who is like the front person trying to establish a company. So, it is when the company is fully established that you now decide what happens. The promoter might just take off his hands and is not doing anything with the company. The main job is just to front and get the company registered. So there are we have different type of business organization. The sole proprietorship, the partnership, and incorporated company. Uh, the sole proprietorship is simple. It's just basically the typical one-man business that we are used to. But you could call it a one-person business, probably maybe not using the word one-man business. The business is the same as that of the owner, meaning, it's seen as the person. So the business can live as long as that person lives. So if you check around, if you know any other trader, the moment that trader you dies, that's the end of the business technically. So if you're dealing with any other person at that point, that's a new person entirely. Now that's the nature of the sole proprietorship. So um, it may not be registered by the CAC, you know, by nature, but again, what this means is we don't get most of them registered, but some do register, especially those that has to do with those who has name registration. So they will just do business name in most cases. So that's why you have, cases like ABC Ventures. So moving to number two, partnership. Partnership has to do with, the association where you have more than, I mean, minimum of two people. There used to be a cap of 20 people. I don't know if that has been changed. So, but a minimum of two people to make it a partner. And then, they can also have more people as partnership. So keeping in mind, partnership must be registered under the business name provision. So they have to register under the provisions of the CAMA. CAMA is the law that is guiding company and allied matters. So Company and Allied Matters Act of 2020 was recently reviewed. So if this is done, in most cases there are rules determining the existence of partnership in general, and it must be a business. So Partnership Act of Law define business to include trade, vocation, and profession. So the most common partnership you see are those of the profession, accountants, lawyers. They are the most common one you see going into partnership. So the business must be carried on by or on behalf of the partners. So whatever you're doing, it has to be either by the members who are the partners or on their behalf, or they are the one actually doing the business. So we have a case to cite for that purpose. We can't go into that. Let's see how we can run through this. So again, it must be profit making and profit sharing. They must be into the business to make profits. Yes, there are cases of charity, but not for partnership. Partnership are doing theirs for business purpose. So there are other conditions attached to it, and we can also talk about the types of partnership. There's a general partner, and there's also the formation of partnership. So You can also have a partnership deed or the general partnership. A partnership is said to be a general partnership if all the partners are involved in the management of the partnership business. So in this situation, there is no distinction for all purposes between the partners and the business. So in other words, the partnership is not a legal person and does not have perpetual succession. When they say perpetual succession, it means it's not even guaranteed that they are going to live forever. That means um, with one person or with one partner, if one should die, they might see a situation where the partnership does not exist again. The partnership is not a legal person again. So not being a legal person means um, the business is not seen differently. We'll get to understand why we want to use that as illustration. There are times where, when you take the business, sorry, are you there?
Yes, sir.
All right. So there are times where you could distinguish between the person and the business, but these ones they are seen as same as the business. Same is how you see the one man business. They are equal. So if you say he owes you, it's as good as his business owes you. If you say the business owes you, it's as good as the person owes you. But by the time where the business is treated as a legal person, there are times where, take for example, if Dangote owes me today, you know, I might hold him and say, Dangote, Aliko Dangote, you are owing me. But I can't go to his company and tell them in the company that, sorry, Dangote Industry owe me because Dangote owes me. It's a lie. That won't work because that's Dangote Industry, which is fully incorporated, is a separate person or is a legal person. Let me put it that way. Is a legal person to us. Most often, they are also that same legal person you refer to in business can also be called an artificial person. So formation of partnership may be formed through an agreement with or without formality. It may also be formed by default, that is, through the fact of holding out persons as if they were partners. So where there is an agreement, it may be oral or written or under seal. So it is oral when they verbally agree to be partners. It is written where they have a document that states the deals. And it's also under seal when that partnership is duly registered with a seal. The ordinary rules of contracts would apply to determine if there is a valid partnership agreement. A written partnership agreement is called the Articles of Partner or Partnership Deed, which is what we want to move to. If it is under seal, the agreement may be varied by subsequent agreements, express or implied. Express is when it's legibly stated. Implied is by virtue of conduct. Why is this or why is this that? Between the partners and depending on the nature of the original agreement. A partnership deed is a formal agreement under seal that contains the terms of the partnership. Partnership deed should have the following minimum content. So we can have more, but the following, like the name of the partner, parties to the partnership, general nature of the partnership business, the rights and duties of partners. It must be stated, because even though they are partners, they do have usually they are usually, given different what's it called roles, different rights, so which is duties are same as roles. So the mode of admission of new partners, should they want to admit another partner, they should have, stated modules, or will I say module operandi, for them to admit another partner. Retirement of partners, what condition should the partner retire? Then partnership assets, the solution of partnership, and at all. So the famous act is the Partnership Act of 1890. Just trying to keep that in mind. Or the partnership law of the state of the federation in which the partnership has its registered office. Um, There is a case cited, Achilles versus African Industries and Timber Company. We can look at that, subsequently for self-study. So we also have a cooperative society being registered in Nigeria and all that. Let me quickly move forward. So these are there are several other conditions that we would reference, but for the purpose of time, well, we just need to move quickly. So the solution of general partnership may be dissolved by order of the court, but there are many situations where the solution may occur without any court. The solution may occur without any order of the court in the following situation. So there is a case where they have expiration or notice subject to any agreement between the partners or partnership. So if entered into a fixed term by the expiration of that term. So there are times where you can partner someone and then basically with a term saying, for example, maybe me partnering Mr. Kinjide now, I'm sorry, Mr. Olajide, in this course to ensure that I deliver this lecture accordingly and ensure that the student gets it right between, this term. So which means at the end of that term, the partnership agreement, had expired. So with that, it's a dissolution. We can say it's a dissolution by an implied dissolution, saying we all know that that is the end. So if entered into for a single adventure or undertaking, so this could be also likened to the first one, but again, it could mean we are partners, just for the sake of getting a job done. The moment the job done now is not aligned with a time. There's no specific time to that job, but as soon as the job is done, we can all say it's nice doing business with you. Let's go our separate ways. If entered into or for undefined time by any partner given the notice of dissolution to the other. So this is a situation where either of the partners can say, sorry, I slept last night, I had a dream, and from this moment, I want to stop being a partner to this deal, to this business, or with you. It's nice doing business with you. Bankruptcy or death. So subject to any agreement between the partners, the partnership is dissolved by death or bankruptcy. So if the other partner, died or, has been pronounced bankrupt, so this can also cause dissolution. Charge. If one party suffers if one party suffers his share to be charged for his separate debt, the others have the option of dissolution, of dissolving the partnership. So this situation where somebody is charged for debt and looks like it's going to be huge, considering the stake the person has in the partnership, then you can say, sorry, I think it's better we dissolve this partnership. Let's go our separate ways. Illegality. A partnership is dissolved if an event occurs which makes it unlawful for the business of the firm to be carried on by the member. So this is why somebody is charged or somebody had to do something that is illegal. You can decide to say, sorry, I won't want to associate with you. You can go our separate ways. So these are others when it comes to application by a partner. The court may decree the solution. So there are various ways where this partner can apply, and the court will now say, okay, based on your application, your partnership, has been dissolved. So a partner becomes a lunatic by inquisition. So when the sanity issue comes to play, a partner other than the partner suing becomes in any other way permanently incapable of performing his duty under the contract of partnership. So should that person find difficult to perform his or her duty, that may be the end. So you might just say, sorry, I don't see this guy being able to do this task or being able to do this. So this should call for the hand. Partner other than the partner suing willfully or persistently commit a breach of the partnership agreement. So should that person keep violating, the terms of the agreement they have, then we can also apply to the court, to dissolve it. Partnership business can only be carried on at a loss. So, Yoruba will make it sound like, this is a situation where in all work, if things are not moving as expected, perhaps maybe, their adjustment is not going in order. And the guy says, Ross, I don't think we need to be doing this together. So bye bye. Effect of the solution of general partnership. The solution basically revokes the power of each partner to bind the firm. However, the partners may complete transaction be done, but not finished at the time of the solution and do what they may be necessary to wind up the partnership business. So this is clear. It's just to tell you that even when the dissolution comes up, so there are some certain things that will still be there. So they might still need to perform a task, a function, an obligation, as required by the partnership agreement. So application of partnership property and dissolution. So this also talks about things that still happened, as a subsequent event, to dissolution. So I have cases of partners as agents. Every partner is an agent of the firm and is other partners for the purpose of the business of the partnership. Therefore, a person as an agent has the following duties which are incorporated into the Partnership Act, section 28 to 30. Unlike in traditional agency where such duties arise at common law. Yes, we've talked about common law, so I'm sure you don't want us to go back to it. So
Yes,
we have
sir.
duty to, hello?
Yes, sir. Yes, sir. I can hear you, sir.
All right. So we have duty to render true account or full information to any partner in all things affecting the partnership. So there's a duty, to ensure that the true account and information is rendered to the other party. Do not, duty not to make secret profit. So in the course of carrying on together, as a partnership, you don't, or any of the members of the partnership or any partner will not make a secret profit. And duty to compete with the firm. I'm sorry, duty not to compete with the firm. So you don't try to do things, let me say out of favor in this case. So whatever you're doing now is not to compete with the firm. So we have also the limited partnership. One or more of the members may opt for limited liability, desiring to invest in a partnership without taking part in its management. The partnership is then a limited partnership, and the liability of the limited partners is limited to the quantum of their investment in the partnership. What that simply means is that, you know, technically, you can also still call it a dormant partner, which is what that means is not involved in the day-to-day running of the partnership. But lo and behold, he has he has put in stake his money, to work for him in the partnership. So what that simply now means with the money is that should things go wrong, should that partnership go into debt while running into the business, or even when they want to settle debt or so, that partnership would have its liability limited to whatever is its shares in the business. So for others, it may mean if you are trying to pay, for example, maybe they went into a business and then they run into a big loss. With that loss, they are owing some other people. Those other people now, while trying to dissolve the partnership, wants to still earn their money. They can decide to go and take, oh, partner, hey, you have a Lamborghini. sorry, you are still owing us 20 million. So what that means is we need to sell your Lamborghini to recoup our money. But for this person who only has his investment stake in the business, if after doing that they still need money or they've not been able to pay fully money they are owing, what that simply means they can't come to him. They can't come to touch any of his personal assets to pay back the loan. I hope that is clear.
Yes, sir.
All right. So a limited partnership must be created formally by drawing up a partnership deed that is an agreement in writing and under seal. Always note when you mention or define the partnership deed, it should be an agreement in writing and under seal. So, no, 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 no. There is limited liability partnership. The laws of Lagos State of Nigeria, 2009, was the first to introduce registration of a limited liability partnership in Nigeria. In addition, and for the Republic, for the Federal Republic of Nigeria, Part C, Chapter 1 to 11 of the CAMA, Section 746794, provide the law on limited liability partnership. The CAMA all allows two or more persons who intend to carry on business for profit making to subscribe to and file incorporation documents with the CSE paying incorporation fees are the latter, as the latter may prescribe from time to time. So this could change. That's what that last statement means, that this process could change from time to time. But again, what this is, what it simply means is that we could have this partnership that is with a limited liability in scope, meaning should things go wrong and they say, oh, this limited this partnership is owing us. Partnership is owing us, say, 200 million, and the partnership can only pay 100 million as a business. So, in the case where it is a limited liability, now they can't touch personal assets or properties of the partners except for the partnership ones. Document of incorporation. The CSC prescribed the form of the document of incorporation, which shall state the dash name of the limited liability partnership, proposed business of the partnership, address of the registered office, name and address of each partner, name and addresses of the designated partners on the corporation, and other information on the limited liability partnership as the CSE may require. So the designated partner and his liability, a document of incorporation must specify the designated partners whose particulars and change therein must also be filled with the CSC. To a designated partner, a person must have given his consent if he ceases to be a partner. He ceases also to be a designated partner. Section 750 of the CAMA provides that except as provided otherwise by the CAMA, a designated partner shall be one responsible to do all acts, matters, things that the CAMA requires a limited liability partnership to do to comply with it, including filing of any documents, return, statement, and other reports, either pursuant to the act or the limited liability agreement. So that means there are times where, aside in pursuant to the act, you can also have the limited liability agreement. Then also liable to all penalties as may be imposed by the act on the limited liability partnership for its violation. So name and publication of limited liability name. So there are procedures to be taken to ensure that this name and publication of limited liability name is carried out. Relationship of limited liability partners, except as may be provided by CAMA, the limited liability partnership agreement governs the mutual rights and duties of the partners inter se or between the limited liability partnership and its partners. Pre-incorporation agreement, an agreement in writing made before the incorporation of a limited liability partnership between the persons who subscribe their names to the incorporation documents may impose obligation on the limited liability partner if that agreement is ratified by all partners after incorporation. So what this simply means is that you can have a pre-incorporation agreement, before setting up that partnership. There's also cessation, more like ending of limited liability partnership membership. I hope you're there.
Yes, sir.
All right. So um, there's entitlement at cessation was limited to the liability of a liability, limited liability partnership. Let me share this. Limited liability partner as an agent, liability for being held out, maintenance of account and other records, annual returns. Yes, they have to file annual returns. And it's mandatory for a limited liability partnership to file annual returns with the CAC 60 days after the closure of the financial year in the form and with the payment of fees as the Commission may prescribe. Failing which the limited liability partnership and designated partners shall pay penalties as specified by the CAC. There's foreign limited liability partnership. The CAMA allows a foreign limited liability partnership to incorporate its business in Nigeria, without which it shall not have a registered office in or carry on business in Nigeria, but it may receive notices or other documents. So it is possible that we have a foreign limited liability partnership. What that simply means is this is done by a foreign or a foreign limited partnership, eventually trying to have a relationship with someone in Nigeria as a partner. But again, for that partnership to have a registered office in Nigeria, have somewhere that they can say this is our office in Nigeria, they must, fully comply with this provision by ensuring that they register their partnership with the CSC in Nigeria. So there's winding up and dissolution of limited liability partnership. All partners decide that it should be wind up. That is a consensus at the end. So all partners had an understanding and said, look, let's bring it down. So the number of partners has fallen between 2 or more than 6 months. Okay, so limited liability partnership is unable to pay its debts. Well, typically you can recall all of this. These are common things in what should stop a partnership from being a partner. There's registration of business name. Section 814 of the CAMA 2020 requires individuals, firms or corporations that have a place of business in Nigeria where they carry on business under a business name to register the name under Part E of the Act. If one, where it is a firm, the name is not the true surname and forenames or initials of all the partners. In case of an individual, the name does not consist of a true surname and forename or initials. C, in case of a company, the name does not consist of its corporate name without an addition. So the corporate name should come with an addition of, say, maybe partnership. However, registration shall not be required if the addition So the name simply indicates that the business is carried on in succession to a former owner of the business. So there's procedure for registration. I will advise that you go through it. There is effect of registration, tax specification registration. So again, we look at the distinguish between a partnership and a company. So a partnership exists except a limited liability partnership, which is more like a distinct type of partnership. So the partnership is not a legal person. We said this earlier. Why a company is a legal person. A general or limited partnership that is not a cooperative society or for the practice of accounting or law must not exceed the maximum number of 20. So, like I said earlier, this is between 2 and 20. Conversely, a private company may have up to 15 members, excluding members who are or were employees of the company. So another difference is that the company has perpetual succession or succession rather, and a change in its membership does not terminate its life. So the company continues to live on, even though some members of the company are changed. But in the case of partnership, it may be a different ballgame. So if the partners change, they may even lead to dissolution of the members. Okay, so please just try and read up. This is more like and so on and so forth. A company is an association of persons which is registered as a separate person from its members and known by a name. So this association operates as a unit in all matters, owns properties of its own, and may allow its members to limit their liability, but by so indicating that when the company is being incorporated. So let's go to corporate. Another thing you could mention about this company definition is that it can sue and it can be sued. So a company can decide to sue an individual, while yes, an individual as well can also go ahead and also sue the company. More like suing the company, more like the company is a person. So Corporate Affairs Commission (CAC) is the body established by Section 1 of the CAMA to register and incorporate companies in Nigeria, among other functions. It is a body corporate with perpetual succession and a common seat. It is capable for suing in the corporate names and may not as well as dispose. And may own as well as dispose of properties to facilitate its operation. So that same company now may buy property in its name and also sell that same property in its name. So there are functions of CAC. I will not be able to go through that. Perhaps maybe you'll be able to read about it. It's not something technical.
Sorry, sir. What's the full meaning of karma?
CAMA is Company and Allied Matter Act. Company,
Okay.
then allied, then matters, and act.
Okay,
So,
sir.
okay, yeah, admin proceedings committee. I need to skip that. So a company can be classified, in these three ways. We can have a company limited by shares. We can have a company limited by guarantee, and we can also have unlimited liability company. The company limited by shares is a company whose memorandum of association (MOA) limits the members' liability to the amount of money, if any, that is unpaid on the shares respectively held by them. The company must end its name with LTD or PLC, depending on whether it is privately held or publicly held. Is that clear to you? Try to see if you
Yes,
get
sir.
what I mean. So when you say in this regard that a company is publicly held, what does that mean?
That is held by government or by two or more people.
Sorry, I said when a company limited by shares, that is, a company whose memorandum of association limits the members' liability to the amount of money, if any, that is unpaid on the shares, especially by them. So what this technically means is most times people buy shares in the company, and for example, we can have what's it called? Percentage limited. Now with percentage limited, big percentage limited now has aside to have shares, worth of say maybe 10 million. Now we can say that 10 million, we have just five owners. Each owners, owns 20 million, you know, eventually. So when you now split this, you notice that there are five. But technically, it is possible that they've not paid for that for that 20 million. Maybe they only paid for 10 million of the shares, leaving 10 million. By the time there is debt, for example, if the worth of their shares, the cash one is 50 million, and then maybe the debt they have is like 70 million. By the time you take out all that 50 million, you not tell them because your shares are limited. Your ownership, your stake in the business are limited by shares. Sorry, these shares that you've not paid off, kindly make provision to pay them off so we can pay the debt. So there's company limited by guarantee, that is a company whose memorandum of association limits the members' liability to the amount of money that the members have undertaken to contribute to its assets in the event of winding up. So we have this case where they are signing guarantee that look, should this company be going down, I'll contribute this, at my own stake for the assets in the event that winding up was going to happen. Basically is to guide or give reliance that a company won't just wind up and there won't be some genuine responsibility. So we also have unlimited liability company, having members with unlimited liability and ending its name with ULTD. So you don't see it common in Nigeria. In fact, the one I had earlier, I think I later had to remove it. So there's a private company. Private company has the following characteristics under the camera. It is stated as a private company in its memorandum of association. So in that memorandum of association that is drafted earlier, it has to be stated in it that this is a private company. Its articles of association may restrict the transfer of its shares and also provide that the company shall not, without the consent of its members, sell assets of a value that is more than 55% of the total company's value of the assets. So what that simply means is that you know companies must gain the consent of the members before they can sell some very huge stock of their remittance or of what you have declared as the cost of governance. So and so on and so forth. There is a public company. A public company has the following features: a minimum issued shared capital of at least 2 million naira, a minimum membership of two, and an under sorry, a minimum membership of two and an unlimited maximum membership, a name ending with public limited company or PLC, like Unilever PLC. The capacity to invite members of the public to subscribe for shares. So they must be able to also, when they need to, they can open subscription to the members of the public that please come and invest in us. There's only a small company. A small company has a foreign attribute under section 394. It's a private company. Its turnover is not more than 120 million per year. Its net asset value is not more than 60 million. Okay, so again, we can now go to promoters again. A promoter is any person who undertakes to take part in the forming a company with reference to a given project and to set it going, and who takes the necessary steps to accomplish that purpose, or who, with regard to a proposed or newly formed company, undertakes in part in raising capital for it. So any person you get involved or you engage to ensure that that company, kickstarts, start working, that company or that person is regarded as the promoter. So there are duties of a promoter. A promoter is a fiduciary to the proposed company and must observe utmost good faith towards the company in all the transactions entered into with the company or undertaken for and on behalf of the company. A promoter must not make any secret profit. The promoter may freely sell his property to the proposed company. The transaction between the promoter and the company may be resigned by the company unless after the disclosure of all the material facts known to the promoter, such transaction is entered into or ratified on behalf of the company by one, the company's board of directors independently of the promoter, all the members of the company, and also the company in a general meeting at which neither the promoter nor the holders of any share in which he or she is beneficially interested shall vote on the resolution to enter into or ratify transaction. What that simply means is that all those who have stake, all those who by nature should have interest, may not be able to vote in the meeting. And please just try to read on this remedies for breach of voters' duties. Are you there?
Yes, sir.
All right, so we're almost through. You need to read these remedies. Share of the contract, recovery of secret profit, recovery of damages compensation, the pre-operation contract too. So effect of the registered document, consequences of incorporation, corporate personality. Yes, when you register, or when you incorporate a company, then that company or that corporate has a personality. Sorry. So these are consequences anyway, which you can detail. There is a limitation of liability. Technically means, whatever you can get from that company in the situation where you're trying to get your debt or is being liquidated, you are only limited to what you can even get from it. So there's also the property being purchased, by that company technically belongs to the company, not to the individual MD or so, but that property belongs to the company. So should someone else take over from the office, that property has to be transferred. Suing and being sued. Because the company now has a legal personality, the company can sue and can be sued. Perpetual succession. So we had explained this earlier. I don't know if you can recall. It's basically about the fact that in spite of changing the membership, the company should still continue to be who it is. Let me put it that way. So borrowing to a company may borrow money in its own name, unlike an incorporated body whose members have to borrow money in their personal capacities. What that simply means is that should partnership need money, the partners can go to banks individually to go and borrow money. But when you have them all encompassed under, the structure of a company, they'll take money in the company's name, not in the individual name this time around. Transfer of shares, lifting the veil of incorporation. So this simply means, when those who claim to have, for example, power, or who claims to be at the top today in corporate world, um, when you bring them a bit down, they tend to understand, oh, really? So you guys exist here. But while they are there, no, they don't get it. All right, so this is 9:58 by my time. I want to say it's been nice having this session with you. Any question before we call it a day or a night?
No, sir.
All right. So this will also be available for review. So members who are not here can go through it, to get better understanding. But should you still have questions, please don't hesitate to reach out. All right. Thank you.
Okay, okay, sir. Yes, sir.